Okay, I think we can get started. There's still some people joining us, but they can always arrive at a later stage. So thank you everyone for being here today with us. It's a real pleasure to be here again for our first edition of the Sanctions webinar as part of our Scopes webinar series. My name is Ilana Krancenblum. I'm the CEO of Scope. I'm currently based in our Tel Aviv office, and joining me here today is Lev Yuriditsky, our head of intelligence, who leads our entire research team and intelligence division across the world. He's currently in the US, so different time zones, but available for the interesting webinar series. Today we're going to be discussing various sanctions regime, how they impact the KYC process, and what you can do to mitigate your risk of exposure. We're going to present a few case scenarios and try to flag out anything to look out for and see specifically how to find these red flags as well as mitigating factors in sanctions exposure. So I hope that you find the webinar relevant. Just want to mention that, as always, you can ask your questions after the presentation. They will be addressed. Do not hesitate to share them in the chat box that you see at the bottom part of your screen. And we'll select as many as we can if time allows for it. And we'll be fully available also after the presentation, of course. But before we begin today, I'd like to tell you just a little bit about who we are and what we do. And then Lev will continue the presentation. So in a nutshell, who are we? Scope was founded over 10 years ago in Luxembourg. We're today located in 3 main jurisdictions: Luxembourg, Switzerland, and in Israel, where we have most of our intelligence division. And we provide our clients from various industries with KYC, AML, and CFT reports, and as well ESG reputational assessment. We today work for over 250 clients that benefit from premium intelligence, transparent sources, and fast delivery of reports. Our clients are based across the world, so are our team, and we have intelligence specialists and experts that speak over 20 languages that ensure that they can do research in local jurisdiction. We cover, as part of our research, over 100 countries. And something else to be mentioned, which is very relevant for our clients, is of course that we are fully GDPR compliant and ensure full confidentiality of our clients. So by ensuring that our clients are receiving, top information, we provide them with AML and anti-corruption reports. And that enables them to get a deep and ongoing knowledge of their clients, prospects, employees, and business partners as well. So that's it for me. Now I hand over the mic to Lev. I hope you enjoyed the presentation, and feel free to ask any questions, and we look forward to answering them at the end of the presentation. Lev, the floor is yours.
Thank you, Ilana, and thank you to everyone for joining us. As Ilana said, I'm the head of intelligence for Scope. I'm usually with Ilana in Tel Aviv, but I'm based today in my family's home in Baltimore, in the USA, which is my favorite port city in the world, probably. Welcome you all to come join someday. So as Ilana said, today we'll be speaking about sanctions in a more general perspective and how they impact KYC. I will touch on different sanctions regimes. I'm not getting too much into particulars, but more using them as examples of the main points I want to get across. We do wish to present more webinars on sanctions and get more into the specifics of the different sanctions regimes in the future, be it Venezuela, Iran, Russia, and Ukraine, and various others, because there are, and you'll notice in this webinar that there are important particulars that need to be taken into consideration. But to start with, it's important to understand that in general, sanctions, the sanctions risk has a lot of similarities regardless of which jurisdiction we're speaking of. So as far as today's agenda, I will discuss sanctions as an overall matter for KYC. I will touch on the various sanctions regimes as well as the sanctions enforcing bodies, who decides what are the sanctions, how they implement them, and essentially what are their powers. We'll talk about sanctions and compliance and why it matters, why do you need to do this, Why is this an important webinar to participate in, essentially? And we'll discuss the different red flags. Many of them apply to to all the jurisdictions across the board, and you'll see that some of them are familiar if you've participated in AML webinars that we've hosted, amongst others. Also, we'll talk about mitigating factors, which I think are at least as important as the red flags. As much as you want to be cautious of avoiding risk from sanctions exposure, you also want to not reduce the opportunities for business by not cooperating with someone who actually doesn't have as much risk exposure as you might have thought he had at first. So mitigating factors are also equally important. We'll share some tips, how we cross-reference information, how we really do everything we can to ensure that we fully understand someone's sanctions risk, both from a red flag perspective and from mitigating factors perspective. And we'll also present some case studies to really drive the message home about the different elements we're discussing. And as Ilana said, you can always ask questions at the end. I'm happy to answer them. And also you'll be able to reach out to me directly if there's something that you think of later. It's a topic I'm happy to present on and happy to discuss. So please feel free. Any questions, I'm happy to answer. So just as an overview of sanctions, obviously many of you are very familiar with the different kinds that exist and the general sanctions that impact the work that you do and the work that we do at Scope. Most of the time we think about the sanctions that relate to direct business, be it onboarding a client, be it cooperating in trade with a sanctioned entity, be it in some way, shape, or form being having kind of contact with a sanctioned individual or their finances. But there also are a variety of sanctions that fit into this category that are less directly related to finances. There are even sports sanctions, as Russia was sanctioned from the Olympics because of the doping scandal that came out several years ago. There are cultural sanctions, there are diplomatic sanctions, arms embargoes, and things like that. And in some way, shape, or form, they do actually impact KYC. For instance, if there's a sports sanction, there are potential that it could indirectly impact a client, but these aren't the things that we're going to focus on. We're talking mostly about economic sanctions and basically the inability to cooperate with a certain country, or also that could impact the ability to cooperate with individuals. This will usually be listed as a specially designated national, meaning that, let's say, an entire country is not sanctioned, but particular individuals within that country are sanctioned. And this happens pretty often. We saw it in Hong Kong recently, in Belarus or Belarus as well. So it's a pretty common thing to happen if a country does not want to punish, if a country or the international community does not want to punish an entire nation or entire sector of that nation, they might choose specific people that they want to essentially say, we're not doing business with you. There are primary sanctions, which are very common these days. Essentially, we cannot work with this country, or you're not allowed to cooperate with a particular sector in a country. But now what's more common, and it's a pretty severe penalty, is the secondary sanctions, which essentially is that OFAC, which is the part of the U.S. Treasury, will tell you that you as a separate person cannot operate with a country, could not cooperate with the country that we sanction. So essentially the U.S. won't allow its nationals to deal with Iran, but the U.S. will also not deal with other nationals that deal with Iran. So it's kind of a really strong stretch of the U.S. arm. And there are also sectoral sanctions, which differ from traditional sanctions in the sense that they target specific businesses within a specific sector, within a specific country. And it's meant to essentially punish the most important businesses within a country that is targeted for sanctions. And I'll get into now a bit about why a country or an individual will be targeted for sanctions. So there's various reasons. One of them, for instance, is diplomatic pressure. Effectively, if, let's say, in the case of Venezuela, and I want to also say before I get into these different examples that sometimes these all go hand in hand. So, for instance, if the U.S. wants the Maduro regime to step down in Venezuela, they might use sanctions as a form of diplomatic pressure. in order to do so. It could be a means of criminal enforcement. For instance, if they believe that a country is supporting criminal acts, be it that they support, by the way, this was the case with Venezuela as well, they support narcotics trafficking, they might use sanctions as a way to weaken the government there and also to punish them for their support, direct or indirect, or just general inability or unwillingness to comply with international criminal enforcement. So they'll apply sanctions to those countries or particular individuals there in order to pressure them to cooperate. There are sanctions for humanitarian violations. Again, a lot of times this all goes hand in hand. So for instance, there were sanctions levied on Syria which is partly humanitarian, partly for humanitarian reasons, partly for diplomatic reasons. And the international community essentially was punishing them for what they considered humanitarian violations, but also as a form of diplomatic pressure to have the Assad regime step down. This is something that's talked about a lot right now in the case of the Xinjiang province in Western China, where the international community has recognized a lot of humanitarian violations and they want to pressure China to stop. And of course, there's national and international security sanctions. And this is most common in the case of Iran. It's something that's heavily discussed as a means of pressuring Iran to not continue with its nuclear program to develop nuclear weapons. So these are four of the main types of sanctions. Again, there's others. I mentioned earlier the cultural sanctions and sports sanctions, which there are loose connections between these elements here. But these are the four main ones that I want you to understand. Why are there sanctions in the first place? And now that we spoke about that, I think it's important to give an introduction to the main sanctioning bodies in the world. So who is applying these sanctions, and you'll understand throughout this presentation that the most important body that we'll be discussing is OFAC, which again is part of the Department of Treasury of the USA. And there's a reason for that, and I'll get into that later. So firstly, individual countries can apply sanctions for very specific, let's say, diplomatic rows or conflicts that they have with a neighboring country. And there's many of these throughout the world, and we can't get into all of them, obviously. But for instance, if there's a territorial dispute between, let's say, Morocco and one of its neighbors, they can apply sanctions to say that Moroccan individuals cannot do business with Algeria, for instance. Is just an example. The reason I'm not going to get into these individual ones too much is because A, there are a lot of them, and B, if they're not really recognized by the international community, it won't really impact compliance professionals. It doesn't really impact us too much. It's very localized and less relevant. There are United Nations sanctions. The United Nations sanctions are less common because it takes essentially a very strong cooperation between a broad, diverse group of countries. So it means that they're not as willing to do it. There's a lot of potential for political interference, political manipulation in a way that prevents the United Nations from going forward and implementing a sanction. And they're also just not as strong as other countries in implementing sanctions and enforcing sanctions. So there are United Nations sanctions, and usually when they implement a sanction, the other member states of the UN will find a way to enforce them, to essentially bolster the sanctions. The European Union has sanctions, which are very powerful because as it's a very powerful economic bloc, but they have in a way less sanctions than OFAC, which is why I'm focusing on them. Also because what OFAC's reach is very broad, because essentially they can punish anyone who has something to do with the United States economic system, that deals with any U.S. person. And because the U.S. Is such a central country to the world economy, and a lot of transactions are conducted in U.S. dollars, and in an unbiased way, I'm not saying this because I'm based in the U.S., it's a very important country for economic trade. So when they implement a sanction or force a sanctions, it just has a much wider reach than some of the other sanctions regimes that I mentioned. So just to give you a demonstration, I'll say that also I'm sending these slides to you later, so you'll have this as a reference, and it's very interesting to look at. Here's an infographic with examples of the sanctions that are in place. This is a bit outdated by a couple of years, so there are changes to the map that that you'll see. As far as other countries that have participated in sanctions or other countries that are currently sanctioned. But I think it's a very good illustration of the way it works. And here you see it will tell you different countries that are sanctioned, if they're sanctioned by the US, the EU, the UN, all three, or just one or two of them, and also tells you the different types of sanctions that exist against these countries. And so I think it's a very interesting map. And you can also see where the UN participates in sanctions and where they don't. And you'll see that there's a lot of political reasons for these sanctions. Just as a note, it's if you look into the different sanctions regimes that the UN is involved in, or the UN implemented, they're usually countries that are kind of universally understood that they should be sanctioned. These will be countries like Somalia, Sudan, ones that in some ways have a bit less political force in the world and can't convince other people to veto a sanctions vote. So it's an interesting thing to note. That's why you have North Korea there, like I said, Somalia, Sudan. And then there are other countries here that you'll see, such as Cuba or Myanmar, that are only sanctioned by the US, and then Zimbabwe, which is by the US and the European Union. So it's an interesting map to look into, and if it's something that you find interesting, it's also good to look into the why. Why are these countries sanctioned? And that way you get an understanding of how they come into force. So with that introduction, I want to bring it back to the point. Why am I talking about this? Why does this really matter to you guys? Why does it matter to us at Scope? And essentially, it matters for two reasons. The first one, as I mentioned earlier, is the risk. You know, OFAC has a broad reach, and they can enforce sanctions fines against banks, even if they're not based in the U.S., even if they seem to not really have much involvement with the U.S. The U.S. has a very strong reach, so they can enforce sanctions against entities based all over the world, and they do enforce sanctions. And it's important to understand that it's not, ignorance is not an excuse in the eyes of OFAC. If you are involved in a sanctions violation, whether you knew about it or not, you are held accountable by OFAC. They treat it very seriously. There are fines that range from a few $1,000s to several millions of dollars, and prison times of up to 30 years for different sanctions violations. Again, it's very particular. I can't get into the different fines and the different fines for different violations, but in general, if you break the Trading with the Enemy Act, for instance, of OFAC, you will face a fine of $90,000 per violation. So if you've conducted many violations, this really adds up to millions of dollars. So it is something to take very seriously, and to some extent, there's also personal liability involved in violating sanctions. So I want to present to you some statistics just to drive the message home. I'm using 2019 statistics only because it's much better of a reflection of normal years. Obviously, 2020 was a bit abnormal because of the pandemic, but 2019 is a good illustration of how high the sanctions violations fines get. So at that time, the OFAC levied 1.3 billion US dollars in civil penalties. And this means that they fined approximately 800 sanctioned parties. And as of 2019, there are approximately 21,000 entities under the OFAC 50% rule. And not to worry, I will explain exactly what that means. And it's very important, and it's a very important element, especially for KYC. The other reason that sanctions is really important for compliance is what we were talking about earlier, is that sound due diligence can also enable business. We've had several circumstances, and I'll discuss some case studies later, in which one of our clients might have not done business with a prospect of theirs because they were worried about sanctions exposure. But if you do really good due diligence and you actually take the effort and interest in understanding the full picture, and you investigate and cross-reference, you can actually enable business. You can actually conduct business with someone who otherwise you might have nixed because of a red flag. So good due diligence can enable business. And I think that's really important to emphasize. But just to drive the message home about fines, I want to present you another infographic, which I find very interesting. And these are the OFAC fines from the years 2015 to 2021 as a summary for the countries that they fined. And I think this illustrates a couple interesting points. Firstly, it shows the diversity of countries that are fined, even though a lot of them aren't in the US. As you see in 2021, there were no fines in the US. It also shows the financial figure for the year, which I think is really interesting. Again, 2021, we're still in the middle of it, and 2020 doesn't really, was kind of a year that we can forget about to some extent. But you can see the other years and added the figures to really get a sense of the scale and the seriousness that the OFAC takes when it comes to levying fines for violations. So it is really important. And just by way of further illustration, I want to present to you some cases. I can't get into all of them individually, but I just want to show you the variety of reasons that OFAC will levy a fine, and also the individual figures, because the previous slide shows for a whole country in one given year, but it doesn't show that the severity of a fine for an individual bank or institution. So in this case, for instance, Standard Chartered in 2019 was fined $1 billion for breaching the Iran sanctions, which is a significant fine and one the highest ever levied. They were also fined in March of 2020 for violating Russian sanctions. In other countries, such as Bahrain, so it's not just the US that implements sanctions. And this is again touching on the idea I mentioned earlier about individual countries, and that the US, even though it's so powerful, OFAC is not the only enforcer of fines. So in this case, there's an example of Bahrain prosecuting Iranian financial institutions for money laundering, which had to do specifically with sanctions. So this I'll talk about later, but there is a lot of overlap between money laundering and sanctions evasion. OFAC also fined a French bank for $8.6 million for Syria-related sanctions violations. And lastly, and we'll talk about this later, Florida banks are really feeling the effects of US sanctions on Maduro regime. And this is relevant, and this is also very relevant for how you conduct your research and for some of the red flags you'll look for when it comes to Venezuela. But it's just, it's an example of another sanctions regime that OFAC takes seriously, and it just shows the impact that it has on banks and the amount of work that they need to do to really understand who their clients are. So I mentioned earlier, and I've touched a lot in brief on OFAC's reach. So now I want to get much more into why OFAC is so powerful. And firstly, OFAC can assert its jurisdiction over transactions involving US elements. And US elements is pretty broadly defined, and there's obviously millions of them. So essentially any US person, which I'll define momentarily, any element that uses the US financial system, and that means any currency that crosses the US financial system. And it also means anytime you use the US dollar, you're essentially using the US financial system. So you can understand from your experience that this entails a lot of different entities. And it also has to do with US origin goods and technology. So what essentially this is saying is that when the US says we are not conducting business, the US is not conducting business with a particular entity, particular country, a sector, or an individual, they really mean it. And they want that sanctioned entity has nothing to do with the US financial system, has no access to the US financial system. It's a pretty severe punishment, and it could really isolate someone. And that's why there's a lot of money laundering involved with sanctions evasion. So as far as defining US persons, firstly, this is US citizens or residents, regardless of location. So I, as a US citizen, when I'm based in Israel, where most of the time I am, I'm also a US person, regardless of the fact that I'm abroad. This also includes everyone who is in the US, regardless of citizenship. So if you're a Swiss citizen, I don't know, a citizen from Egypt, and you're traveling in the US, you're working in the US, it doesn't matter, you are a US person. This also involves entities domiciled in the US, including branches of non-US banks. It also includes overseas branches of US banks. So I think the message that I'm trying to drive home is that, and the reason I'm mentioning OFAC in particular is because OFAC takes this very seriously, and OFAC has a very broad reach, as you can tell from this slide. Now, as I mentioned earlier, there's a such thing as the 50% rule. And this is really critical to understand for the sake of KYC, and you'll see momentarily how it plays into various case studies. So the OFAC 50% rule is basically saying that an entity will be sanctioned if it's owned or controlled by people or entities sanctioned by OFAC or the EU, because the OFAC does support the EU in certain cases. If there is more than 50% of that company that is controlled by sanctioned entities. Now, what that means is it doesn't have to be owned by one sanctioned entity. It doesn't have to be 50% owned by one sanctioned entity. It could be 5 sanctioned entities that each have 10% stake in a company. If it's 10 that have less than 10% stake, let's say it's 10 entities that have 5% stake in a company, which accumulates to 50%. Then in theory that doesn't count, but I would highly recommend using legal counsel in those cases just to be sure. But generally speaking, this is the idea of the 50% rule. Another part of the 50% rule that to take into consideration is a company will be exposed to sanctions if a sanctioned individual has a possible controlling interest in the company. And then those are the main things to consider. As I said, if the aggregated ownership by multiple sanctions subjects is 50% or more, then the entity is sanctioned. So again, you'll see why this is important momentarily, but I want to really drive that message home. So as we discuss sanctions and compliance, I want to also discuss about why technological solutions are insufficient. We use them as well, and they're certainly a necessary tool to have when you conduct KYC. So I don't discourage it at all, but they are insufficient. This is for many reasons. First off, they're very inadequate for high risk entities. They often miss exposure. So there are a lot of people who we've seen have sanctions exposure, but for whatever reasons, be it the natural language processing algorithms or be it the individuals behind adding someone to the tech solution that you're using. Sometimes it's manual, sometimes it's natural language processing. For whatever reason, they're missed. So we've seen sanctions exposure missed by tools that we use. There are also false positives. This could be falsely inaccurately identifying a person based on the naming conventions, which are not taken consideration. But it could also be including someone as a sanctioned individual based on inaccurate information from the source. And we've seen this a lot as well. Be it, I'll just by way of illustration, if a system pulls from a website, if it has a scraping tool that might pull from a website that this individual, person X, is involved in a sanctioned company, he or she will be added to, will be flagged as sanctioned in the tool that you're using. But there's a good chance that there's an error on their website. And this happens more often than it should. Oftentimes, with a flagged individual, mitigating factors are not taken into consideration. And this is something I mentioned earlier, that it's at least as important as the red flags. We want that enhanced due diligence is a means of enabling business as much as possible, and not just preventing it. But sometimes these tools do not take into consideration the factors that mitigate the risk, and you'll see those in a moment. Context is also very crucial. There are sanctions that if you understand them well enough, you'll understand that they're not taken very much into consideration by the international bodies, and be it because it's one directional from one country to another, or if it's very politically motivated. So there are times that perhaps Russia will sanction a particular body in Ukraine, but that doesn't really impact most of our clients, for instance. So it might be flagged as a sanctioned individual, but the context to understand why is important to understand, again, the mitigating factors therein. They also lack consideration for the jurisdiction, and you'll see why it's very important to be knowledgeable about the jurisdiction of the person you're researching in order to understand the sanctions risk exposure. So the reason, in summary, why tech solutions are insufficient is that on the one hand, they have the risk of inhibiting business, and they also have the risk of mispresenting compliance risk and not displaying the red flags that might exist. So I will speak about a couple countries for the sake of illustration and the red flags for those particular countries, because like I said in the previous slide, jurisdiction is something that's important to consider. But I want to give a general overview of red flags for sanctions risk and the things you have to take in consideration. So firstly, country risk is important, and we provide this in our reports at Scope. If for our clients participating, you've seen it. We expand on why a country is ranked a certain risk level, be it for sanctions exposure, money laundering risk, and things like that. And the reason we do it is because if you're operating with Russia, for instance, if you're conducting business with a client that has exposure to Iran, that should already be in and of itself a red flag. Now, red flags, it's important to emphasize when I say red flag, it does not mean do not do business with this person. It just means it's something to draw your attention to. It's something that you see, and that means that you need to investigate this further. Get to the bottom of it. Get to the conclusion of, is this person exposed to sanctions risk or are they not? It's the same with sector risk. I mentioned earlier sectoral sanctions, which essentially you'll see some examples momentarily, but for instance, the US can levy sanctions on a particular sector in a particular country. So let's say, for instance, in Venezuela, the oil sector could be sanctioned, or the main company PDVSA is sanctioned. So you might deal with a Venezuelan client that's unflagged, but you understand firstly their country risk is Venezuela, their sector risk is oil. You understand that through research, they have some exposure to the oil sector one way or the other. It could be they provide equipment for the oil sector. It could be they provide transport for the oil sector. But as a result of their involvement in it, you really need to understand how exposed they are to that risk. It might be that there might be enough mitigating factors that you can continue to conduct business with them, but there might not be, and they might be a no-go. Connections risk, no matter which jurisdiction you're looking into, you need to understand the connections that a particular individual in a country has to other people in that country. Again, we're talking here about high-risk individuals. So if you're looking at a wealthy or ultra high net worth individual in Russia, for instance, it's important to understand who they're connected to, because they themselves might not have involvement in a sanctioned sector, but they might be connected to someone who does. And again, that by itself it does not mean that they have a high risk of sanctions exposure, but it does mean that you need to conduct further due diligence to expand on that connection, understand how deep it is, how close it is, and how likely is it that it could be a conduit for money with a sanctioned individual or financial transactions with a sanctioned individual. There are other things to take in consideration. Opaque backgrounds. Again, this has to do with money laundering as well, with terror financing. Just generally speaking, if you're looking at a prospect and that person has a very opaque background, and especially if they are from one of these jurisdictions or a particular sector in a risky jurisdiction, it's something to take consideration as a red flag, and that means that you need to uncover that person's background, be it by asking them for more information. And if you see, for instance, in that process that they're hesitant to provide it, that should be a red flag as well. No online presence. So again, it's not always a red flag, but in the case that you see someone who has a company that seems to generate a lot of income, but there's absolutely no online presence of them, there's no website. If it just seems that they do not seem to have the digital footprint of a company in their position, that should be a red flag to you. Again, the same as for money laundering and terror financing, but for sanctions evasion, it applies just as well. So again, I want to give examples of how this applies to specific jurisdictions. We can't get into all of them. I'm choosing, I'll start with Russia, and I'll also talk about Venezuela for the simple reason that there's a lot of sanctions against these countries, and they are countries with enough business interests that flow into Europe and to the US that we in Scope see a lot of sanctions exposure with the subjects we investigate in Russia. So I'm presenting it for the breadth and depth of sanctions in these countries. I also think they're good examples to illustrate the points I'm discussing, and also because personally, I from our experience at Scope, we've seen the highest frequency of sanctions exposure with individuals from these countries. So one thing I mentioned earlier, we're already talking about Russia, so I'll step aside from country risk right now, but sector risk is important. If you understand the jurisdiction you're dealing with, you understand where there are sectoral sanctions. And that's, just as an aside, that is why it's important to, when you conduct research, to have it conducted by someone who really understands the country. Just briefly, at Scope, we have desks for every jurisdiction, and through that, we have experts in these regions, and they're able to uncover nuances that that someone from a different desk would not necessarily see. And I think that's pretty important. I encourage you guys to do the same. If you're researching a subject in Russia, if you can, use someone who understands Russia well, because again, through this, our analysts understand that the financial, the energy, and defense sectors are the ones with the highest level of sector risk exposure. So if you see that, this is a red flag for Russia. Another red flag for Russia that's kind of unique to Russia is that the prospect or his or her business partners are on Forbes' list of wealthiest Russians. Now, at first, that might seem very weird because I'm basically telling you that a private media company is responsible for those who are on the sanctions list. It's not exactly like that. But what happened is, and this has been challenged by a lot of academics and a lot of people in the government, but essentially Forbes released a list of the wealthiest Russians, and it seems to some extent that there's a strong correlation between that and individuals who were added soon after to the OFAC sanctions list. And essentially people say that that the U.S. government used that list to say, okay, we're going to sanction these wealthy Russians, and there's a reason for it. The reason for it is that it's rooted in the belief that the Russia's oligarchs, so to speak, and I use that term loosely, or the Russia's wealthiest Russians, all are connected to the regime. That you can't get to that status of wealth in Russia without connection to the regime. So once Forbes released this list, OFAC, in theory, it didn't actually work like this, but to some extent, used this as a means of choosing who to sanction. Likewise, if a company or client is on Forbes' list of Russia's biggest companies, this is another list that has a very strong correlation with sanctions risk. So the reason I say this, again, we're talking about red flags. This does not mean that you should not conduct business with this person. You should not onboard them. That's not what it is. What it's saying is that once you see that, that should be something to draw your attention and to be a trigger for further investigation. Another one is having assets or business units in Crimea/Eastern Ukraine. As we know, it's a disputed territory, Crimea, so to speak. It's not recognized as part of Russia. Russia annexed it for itself. Again, it's disputed in Eastern Ukraine is also an area that's is in a way disputed. Essentially, again, without getting into the politics of it, we all know that Russia is supporting rebels in Eastern Ukraine who are seeking to take over the territory, not dissimilar to what happened in Crimea. So if you have assets, if there's someone with interest there, with business interest there, there's a high likelihood that they're exposed to sanctions. Not everyone who conducts business in Crimea or Eastern Ukraine is sanctioned, but again, it's a high risk that in order to operate there, they're going to be in touch with and cooperating closely with sanctioned individuals who are operating there, because there are many of them. And again, just to bring back to the main point, this is why it's important to really understand the jurisdiction you're dealing with, and not just use a blanket approach to all countries where you're doing KYC research. Another element is if the company has a stake in a recently failed Russian lender. And the reason I say this is because some years ago, there was a lot of lenders throughout Russia who were struggling financially, and they were bailed out. They were bailed out by the Russian government, they were bailed out by businesses that are partly owned by the Russian government. So what that means is that if someone has a stake in a Russian lender that's currently existing but recently failed, there is a strong chance that they were bailed out by a company with heavy Russian governmental or political interest. So it's something that means that you have to go further and understand who bailed them out, where they bailed out, who bailed them out, and the company bailed them out. What level of exposure do they have to sanctioned individuals or sanctioned sectors, and things like that. So these are good triggers. There are many more. Bottom line, really understand the person that you're considering, and use this as some of the things to investigate. Just to show a bit of diversity and kind of illustrate how these things, on the one hand, kind of there's similarities jurisdiction to jurisdiction, but that there are also differences between them. So in the case of Venezuela, some of the red flags could be transactions involving government contracts, because the Venezuelan government is really heavily sanctioned in broad strokes, especially because the US wants to oust the Maduro regime. They see them as illegitimate. So many in the Venezuelan government are under sanctions. So if you have if a client has transactions with government contracts, it's important. It's an important and very relevant red flag for Venezuela. Unlike Russia in the sectors I mentioned there, in the case of Venezuela, any activity in the public sector and strategic sectors, mainly oil, which is a primary source of income for Venezuela, as well as gold and financial services, is a red flag for sanctions as well. I mentioned earlier, I showed a clip from a newspaper about Florida. And this is very important because based on the proximity of Florida to Venezuela, as well as the, I would say, Latin heavy influence in Florida, especially in South Florida, there are a lot of wealthy Venezuelans who have connections there or who operate their own assets in South Florida. Many of them are being frozen at this time. But essentially, if someone has an export business that's operating in South Florida and engaged in trade from Florida to Venezuela, this is a really bright red flag to take a look at. In general, Venezuelans in South Florida, so this is kind of an interesting illustration of jurisdictional risk, because it's not strictly related to the country exposure, the main country exposure of the person you're looking into. It's also the kind of a secondary country exposure of Venezuelan in South Florida, which I think is very interesting. It's also not too dissimilar for a Russian operating in Crimea or Eastern Ukraine. But again, in this case, if you're operating a business in South Florida that's engaged in trade from Florida to Venezuela, there is a high risk of sanctions exposure. Likewise, transactions for high value assets. This could be real estate, aircraft, sometimes high value luxury vehicles. And if these transactions involve Venezuelan political officials or their families, this is something that's this is also a potential red flag for sanctions exposure, even if it's not flagged in the tax solutions that you may use. Just a connection to the Venezuelan political establishment and doing business with them is something to take as a red flag. So I spoke a lot now about the red flags. As promised, just as important are the mitigating factors. The things that basically you see these red flags, you do some investigation, and you see sanctions exposure risk, but you want to ask yourself, can I still do business with this person or company? So firstly, I want to talk a bit about sectoral sanctions and the risk of them versus specially designated nationals or list-based sanctions. And it's important to understand that the risk is slightly reduced with sectoral sanctions. And partly the reason I'm saying this is because with the SDN, or specially designated national sanction, essentially the sanctioning body is saying, do not do business with this person. That's it. They provide a list of people you can't do business with. And it's very clear cut. With sectoral sanctions, it's essentially a form of light collective punishment, saying that we know that Venezuela, your primary source of income is oil, so we're going to sanction the main oil company in Venezuela. Or if we're using a different example, a technology company in Russia. There's a lot of them, and they might be under sectoral sanctions, but because there is no element of wrongdoing on the part of the company necessarily, the sanctions, the reputational risk is reduced. Again, in the case of an SDN sanction, someone did something wrong and they are targeted because they did something wrong. In sectoral sanctions, the country did something wrong in theory, and the government that's imposing the sanction wants to punish them, so they punish businesses within a particular sector. So you can see that it doesn't mean that this particular company or an individual involved, that company did anything wrong. So it's important to understand how exposed they are in that sector or to the business in that sector, and just understanding that it's a bit lighter and there's a lot more leeway when it comes to sectoral sanctions from the perspective of the US. The exact timing of the affiliation is really important. Essentially, we've seen, and I'll give you case studies, that someone is involved in a sanctioned entity, but their involvement ended before the entity was sanctioned, which essentially means that they are not exposed to it, even though it might seem at first that they are. And oftentimes this is where the mistakes are made in technological solutions, where someone will be listed as sanctioned because they're listed on a website somehow at some point that for a company that is sanctioned. But that's where you really need to dig deeper and verify that person is still involved there. I mentioned the 50% rule. Again, if someone's exposed to a sanctioned entity, but through a company that they're involved in, understand the level of involvement that the sanctioned entity has in that company, for instance. And if it's collectively less than 50%, and you can confirm that, then the sanctions risk is reduced. If someone has family ties to a sanctioned entity, if you can provide evidence that the family ties are strictly family ties, then this is a mitigating factor, and you can relieve yourself of some of some sanctions risk. So long as, again, you can prove that this person is a cousin of a sanctioned entity, but it's strictly that they have no business dealings with them. The sanctioned affiliation is not the prospect's primary source of income and funds. Essentially, the level of involvement that the prospect has with a sanctioned entity is important to take into consideration. You know, having 1% share in as an example, having 1% share in a sanctioned entity does not make your sanctions exposure risk that high. Once sanctioned, not always sanctioned. This is important also because essentially you might find someone has sanctions exposure to a company that is no longer sanctioned. It's kind of related to the timing that I mentioned earlier, but in the reverse spectrum, the sanctions ended and the person is now involved with them, rather than the person's involvement ended and now the company is sanctioned. And lastly, and this is important to take in consideration, there are various clauses and exceptions specific to sanctions regimes that you need to take in consideration. And again, they vary for every jurisdiction. In Iran, for instance, you can do business with Iran for civilian aircraft trade, for humanitarian deliveries and things of that nature. There's a lot of cases where you can do business with Iran. And again, these are clauses and exceptions that are jurisdictional specific, and that's why it's important. That's why we will do sanctions webinars on the different jurisdictions. That's why it's also important to have someone do research who really understands the jurisdiction in question. Like I said earlier, I'm going to send these slides to everyone so you have them. I'm going to go a bit faster for just a moment, just for the sake of time, and I want everyone to have a chance to ask questions. So you will have a list of these. It's essentially, this is a general guideline that we use when it comes to conducting due diligence. What do we want to walk away with? What knowledge do we want to obtain about a person or an entity? In the case of a company, you want to know their owners, their clients, vendors, all subsidiaries, primary creditors, and the region and sector of activity as a baseline. You need to understand this. And this is the base to understanding a company's sanctions exposure. For a person, you need to know the companies. But then again, once you know the companies, I redirect your attention back to the first list. That's the things that you need. Those are the things you need to understand about the company. That's why when we do reports on individual, we also expand heavily on the companies that they're involved in. We also need to understand their business partners and family members in order to understand sanctions exposure risk through that. And again, these should all be standard practice. And I want to emphasize that you should cross-reference to know for sure the information that you're finding as best as possible with as much confidence as possible. You should look at corporate records, company findings, press reports, and other information you can find. understanding that commercial databases in and of themselves are important starting points, but they're not sufficient. There's a lot of errors in them. Sometimes there's self-filed information, and sometimes in certain countries you simply can't find the information. So looking at the whole spectrum of available sources is crucial to understanding the risk exposure as well as mitigating factors. So just to emphasize the points I made earlier about the things to look into, we had a client that was considering to onboard a prospect who seemed to have sanctions exposure. Essentially, according to corporate records and commercial databases that we checked, the individual did have exposure to a sanctioned company. But we didn't stop there, and there's no reason to stop there. We need to confirm this for ourselves, because again, it's an important question of can you do or can you not do business with a potentially lucrative partner. So we did check the current company website, and we saw that the person was no longer listed there as one of the directors. And so that was the first reason for us to suspect that maybe the sanctions exposure ended before the sanctions began. So then we used a web-based tool. It's the Wayback Machine, if you will. I talk about this in some of my other webinars because it's an important tool for open source intelligence. And we saw in archived copies of the website when exactly the person left. We can pinpoint the day that the person was removed from the website. And we saw that it was precisely or approximately a year before sanctions against that company began. We also checked more current company filings and saw that the person was no longer listed as having involvement in the company. And lastly, just to understand where the error came from in the commercial database, we checked the sources that the commercial database used and the corporate records that they were based on, and we saw that they were outdated. So this is just example of the errors that you'll find and why it's important to not just depend on commercial databases. In another case, this is changing jurisdictions for a moment in Venezuela. We saw an individual. So this is a different. This is talking about the opposite of mitigating risk. This is of mitigating factors. In the first case study, we talked about mitigating factors. In this case, it's actually risk that was not identified. So in commercial databases, there was no flagging of any sanctions exposure. But when we did our own research, we found that the person is linked to sanctioned entities owned by the Venezuelan government. He was linked to specially designated nationals, which I said earlier was a much higher risk. And they were narcotics traffickers, which is even greater risk, even including for reputational purposes. The person was also linked to a company that acted as an intermediary for major U.S. investment companies purchasing sanctioned PDVSA bonds, and that's the oil company in Venezuela. He was also alleged to have served as an operator for high-ranking Venezuelan political officials. Again, these are all major red flags. The fact that he was not listed in the commercial databases does not mean that you can conduct business with them. That's for your own decision-making, obviously. Our role is to just provide the facts. But this is something that if it was not flagged and there was no further due diligence conducted, our client could have found themselves in a lot more risk than they're willing to take. The last case study I want to provide is also regarding Russia. We had a situation, again, unidentified risk. There was a subject who was not listed in any major sanctions list, but the subject's uncle is a high-profile businessman with political exposure and very close ties to Putin, and was included in the Kremlin list, which is a list that essentially a political rival of Putin released, encouraging Western governments to sanction these individuals. And it's just like the Forbes list, it's used quite heavily. It's important to note also, again, just bouncing between risks and mitigating factors, is that secondary sanctions can be applied on children, spouses, parents, or siblings, but not nephews. So that kind of reduces the person's risk. But just more about the uncle is that he is also an SDN, specially designated national due to his involvement in the regional dispute in Ukraine. But the subject himself also had exposure and associations with different sanctioned entities. So again, these are a broad range of risks that this entity had, and it's up to our clients to decide, do we want to take them on or not? But without conducting enhanced due diligence, they would have never found the the other red flags and the other risk exposures in order to have the information to make the decision that they need to make. So I hope you all found that interesting and relevant. I hope there's things you can take away from there. Without further ado, I am happy to take any questions that you may have.
Thank you, Lev. That was very interesting. I really enjoyed the presentation, and I'm sure that the audience did as well. We've received several questions, but I think we're pressed for time, so I guess I'm going to select one which actually was asked by several people in the audience, and we can address then the other one separately. And of course, as mentioned earlier, we're fully available after the presentation. We'll send you the slides of the webinar, and there will be a recording as well if you'd like to share it on your different platforms. So in terms of the only question that I'm going to select, Lev, how do we check if a client has sanctions business partners?
That's a very good question, and it's also, again, it's a very important part of what we do. We don't just look at the individual, we looked at their partners. It really depends on the country. Generally speaking, the first starting point is official corporate records. If you can obtain these, and for a lot of countries this is obtainable, these are obtainable. Many others they're not, and you have to find a way to obtain them. That's the starting point, official corporate records. In addition to that, you should also look at news reports, especially for high value companies. If it's the kind of companies that our clients will be involved in, or that our clients will be involved in, there will be news reports on them, and they will usually talk about their partners. They will usually discuss who else is involved in the business, if there's any important investors and things like that. So news reports, time-stamped news reports are very important to use. Try to limit it to the time that the company was established, or some major action that the company took will be a great way to limit the noise and get to the bottom line of what you're looking for. Corporate filings are also very important. They have a lot of information about partners and things like that. Again, the importance is, don't just stop with either one of these elements. Again, if I break it down, it's corporate records, news reports, corporate filings, but cross-reference them. Make sure it's accurate. Make sure the information provided is accurate. Really walk away with a sense of confidence in the information that you find, and that's what you need to do.
Thanks a lot, Lev. So I think that concludes the webinar of today. Once again, it was a real pleasure to have everyone join us. Do not hesitate to contact us, and you can do that through our secured portal online that you have the link in the slide and that you have in front of you. Thank you, everyone, and we wish everyone the pleasant rest of the day wherever you are.
Thank you all.
Thank you.